Hey everybody, thank you so much for attending our webinar today. A little bit of a unique situation for a conference, but it doesn't mean we can't get a lot of value out of the content today. Thank you so much for putting this together, Eric and ComedyCE.com. My name is Tyler Borders with Benefits Compliance Solutions, and this is my partner, Sarah, the compliance guru. And we're going to be talking about some practical tips to stay compliant during this period of time that we're all living in with COVID-19. I think we're all aware of some recent changes, some pretty significant changes to the regulations that govern employee benefits plans. And we're going to walk through some of the common things we've been hearing from employers. We've spoken to literally hundreds of employers over the past few weeks about what they're seeing. And we hope to answer some of those common questions to help you to stay compliant. So starting out, first question is about keeping employees on the plan. There's a lot of furloughs. There's a lot of layoffs obviously going on. Do employers have to keep their employees on the plan in these sorts of situations?
Well, what I've been telling employers, because this is a very unique situation right now that we're in. So it all goes back to how the plan document and the carrier's certificates of coverage define eligibility. So normally in the normal world, before COVID-19, you would typically look at the definition of eligibility under the plan contract. And usually it would say something like, someone who's eligible for coverage is a person or employee that would work 30 hours or more per week, or is regularly scheduled to work 30 hours or more per week. And maybe there's an actively at work provision, which means that person has to actively be working. There's going to be times when a person is on FMLA or some kind of approved paid leave of absence or unpaid leave of absence, and some plans do allow for those instances. Now, I will say that many of the carriers, fully insured carriers, and some of those who administer self-insured plans, like for example, if you have a level funded plan, they are relaxing eligibility requirements right now. But it really differs upon which carrier is doing what. So you're going to need to check on what that carrier is doing. And don't forget about your ancillary carriers. So medical is vitally important, but also you need to think about the life plan as well as the disability plan, because those usually have a distinctive actively at work provision. And what could happen is someone has a claim while they're out on furlough, the employer believes that they're still eligible for coverage, and then finds out later that they are not because the claim's denied or something like that. So you really, really need to double check with the carrier on what to do in these situations.
Great. All right, another common one here is about keeping employees on the plan if they're on emergency paid sick or family leave. There's been some FMLA updates, I believe, as a result of the CARES Act.
Yeah, so this is really important because what the FFCRA Act did is it expanded this emergency paid leave, and it falls under FMLA leave. So FMLA leave has been around for a long time, and the traditional regular FMLA leave really just gives somebody job protection and allows them to stay on the benefits as if they were still employed. So what this does is it further expands those rights for certain employees, and it actually expands the type of employee that can receive these paid leave entitlements. So as far as the health plan goes, you're going to need to maintain benefit coverage for the health plan as if they were still working. So what this means is if they had medical, dental, and vision before they took the leave, you're going to need to keep them on the plan as if they were still actively at work, the same coverage. Now, they could elect to drop the coverage voluntarily. This is generally a qualifying event under the Section 125 rules. But for the most part, people may want to continue their coverage as it was. Now, does this mean that you have to pay 100% of their premiums, or do you get them to pay 100% of the premiums? And we're going to talk about that in a few slides from now. So we'll touch on that.
Keep moving here. Speaking of keeping
Yes.
employees on the health plan, this stuff is not free,
Right.
right? These premiums are going to keep coming. How much can we charge employees? Is the full premium recoupable? What does that look like?
So in the situation where you have FMLA leave, or some employee is able to continue or receive paid leave through one of the emergency paid sick or family leaves, in that instance, you do not have to pay 100% of their coverage while they're out on leave, okay? There's really no scenario where you have to pay 100% of an employee's health plan. That could be something that you decide to do as long as it's not discriminatory, but that isn't required by law under any law that I know of anyways. So if they are out on one of these qualified FMLA leaves, then you have to charge them the premium that was in place prior to the leave. So the cost has to be maintained. So what employers can do is they can set up a certain type of premium contribution structure that can be paid via personal check or through pre-tax salary reductions. So it's just something that you'll need to think about now so that you have a plan in place to put in action when it becomes relevant for your organization. So again, you do not have to pay 100% of these employees' leaves. If they are terminated, if they terminate employment, then at that point you put them on COBRA, and that of course is paid 100% by the former employee, so, or qualified beneficiary.
Right. Now, speaking of collecting those premiums, what does that look like? Obviously, if we're perhaps not giving a paycheck, or that paycheck is a lot less than what it might be normally, how do we collect those premiums during this time?
Great question. And we always look back to the FMLA rules that outline how to collect premiums while somebody is out on FMLA leave. And they're a really good guide when an employee is out on an unpaid furlough or unpaid leave of absence that is outside of the FMLA mandate, the FMLA protections. And it's just a good guide in general if somebody doesn't receive a large enough paycheck to pay their premiums. This could apply if you have servers and maybe they get tips and their paychecks are really small. So just keep this in mind as kind of a general guide on how to collect premiums when the paycheck is not large enough. So there's 3 ways that you can do this. You can have somebody pay in advance if the leave is foreseen. In the situation of COVID-19, that's not always going to be really feasible, but in some cases it might, like maybe the daycare, they know the daycare is closing next week or something, or the school is closing, and that is one reason that you would receive paid family leave. Then the employer can work with the employee to prepay maybe over a few paychecks via check, personal check or pre-tax salary reductions to be able to pay for the duration of the leave. Now, a lot of times you don't know how long the leave is going to be. This is was meant for maternity leave or maybe an elective surgery where you're going to be out for this defined period. So just know that the prepay option is there, but it can be a little bit tricky in the situation where the leave is not foreseen. Now, the next way you can pay is through pay as you go. So this is probably preferable because people are supposed to make periodic payments and installments, and that can be done again through personal check. And you could do this monthly, or you could do it by the pay period that's normally their set pay period. So if you choose this option, you'll just need to communicate to employees that this is the way it's going to work, and that you have to give them at least a 30-day grace period to catch up on their premiums. And you're going to need to notify them at least 15 days in advance that their premiums aren't paid and that their coverage is going to be canceled. So if you use this method, communicate, you got to keep documentation, you got to keep up with all these checks. Now, there are a lot of really good vendors who normally do COBRA that are switching gears here to be able to collect payments for people that are still active. They're just furloughed, but they need to collect premiums in an organized fashion and communicate their status to the employee. So I would recommend looking at one of these vendors to help collect premiums if you have a large population that's going to be paying as they go. The last method is catch up when you come back. So this one, some employers are going to have to use this method. But just be cautious, because if the employee doesn't come back to work, then it's almost impossible to recoup premiums if they're no longer receiving any pay from which to withdraw premium deductions. So if they come back to work, then you can work with the employee over a few paychecks to recoup your premiums that were not paid during the time of leave. But just, again, be cautious with this, because you could wind up paying a couple of months, if it goes on for a few months, of somebody's premiums that you really weren't planning on doing that for. So those are the three methods. Again, you need to communicate it, whatever you decide to do, and get it in writing, and even have the employees probably sign off on that as well.
Super important. Now, what about COBRA? Obviously, that's different than FMLA, and in the state of Texas, obviously, we have Texas state continuation. How does that come into play in the situation?
Great question. So COBRA, let's look at that. Federal COBRA applies to employers with 20 or more employees, full-time and part-time generally. So if you are subject to COBRA, then you will need to offer COBRA to somebody when there are two parts. First of all, they have to lose eligibility for coverage because of either a reduction in hours or termination of employment. So in other words, the reduction in hours or termination of employment has to cause them to lose the eligibility. There are other reasons why somebody wouldn't lose eligibility for one of those two reasons. So there has to be those two things that are kind of triggering the COBRA event. So remember that in this instance, when somebody loses eligibility because of the reduction in hours, you would terminate them from coverage. They would likely lose coverage at the end of the termination month if your plan operates that way, or the day of termination, just depends. And at that point, you would need to offer COBRA to that employee. Now, Texas state continuation is for fully insured groups that are less than 20, so 2 to 19 employees, or larger groups that are subject to COBRA, and it kind of tacks on an extra 6 months of continuation rights after COBRA is exhausted. So if I stayed on COBRA for 18 months and my former employer's plan was fully insured, then I would have this extra 6 months of COBRA rights. If you are 2 to 19, then remember that state continuation allows somebody to stay on the medical plan for up to 9 months. So just remember that there's this extra little state nuance that is triggered when somebody has a reduction in hours or termination of employment that causes them to lose eligibility. Also remember that that when somebody is on a furlough, for example, and you are going to put them on the furlough and keep them active on the plan, then when that furlough defined period or that layoff period ends, at that point is when you would offer COBRA, when they are terminated off the plan. And that could be, the end of April, the end of May. It just depends on how you're going to define this kind of extended eligibility requirement. Lastly, when somebody returns or does not return from FMLA leave, they have taken the FMLA leave. Again, you don't put somebody on COBRA or offer them COBRA when they're going on FMLA leave. That's the big no-no. You would offer them COBRA if they exhaust FMLA and they don't return to work. So just keep that in mind.
Good info. So what about employees in a look-back measurement period that have less hours? I know there's certain eligibility requirements, part of ACA. How does that come into play?
So this is a really important issue, because if you're one of the employers who's subject to the employer mandates, you're an ALE, then you can use what we call a look-back measurement period for your variable hour employees. Now, what's that? Variable hour employees are those that have varying hours. You're not sure if they're going to be full-time when you hire them. So instead of trying to constantly figure out, okay, do we need to offer this person benefits? You know, a lot of employers struggled with that before the ACA. So this can actually be helpful because it allows you to define this 12-month a 12-month period. It can be different, but 12-month is usually the standard time, where you can measure an employee's hours over the 12 months. If they average full-time hours after the 12-month measurement period, then you can say, okay, you're considered full-time. You've earned that status for the full next stability period. The stability period has to match the measurement period. So if you use 12 months for measurement period, you got to have 12-month stability period, meaning I've earned it for 12 months. My employer cannot take this if my hours dip below 30 during the standard stability period. So in the case of furloughs and reduced schedules and maybe no work at all, if they're still active, like maybe you have a lot of waitresses or waiters or PRN employees, then you need to understand that the reduction in hours for one of these types of employees, variable hour employees, would not make them ineligible. They have to stay eligible for the entire stability period, including this time. Now, if they actually terminate employment, maybe you just lay them off, and maybe you would rehire them later, but they're no longer your employee, you've severed that employment relationship, then you would just offer COBRA in that case.
So this is a pretty common question right now. What do we have to cover, right? So there's been some changes that mandate to tests and treatment related to COVID-19. What are employers actually required to cover now that might be different than what it used to be?
Yeah, very important right now, very confusing. Many states have different coverage requirements. If you are located in Texas and your plan is situs in Texas and you're fully insured, Texas didn't actually mandate any coverage requirements. Now, the federal government did through the legislation that was passed, which says that COVID-19 testing for COVID-19 specifically, and any provider visits that are around the testing, meaning you have to see a doctor, you have to get the order from the doctor, you have to have a telemedicine visit from the doctor, you go to urgent care, and they order the test or perform the testing in that doctor setting, then that testing would have to be covered by the plan, as well as the provider visit attached to the test. Now, a lot of carriers are saying, yes, we will cover that, of course, because we have to, but they're also expanding it to treatments related to testing. So this is not mandated, but your carrier may be doing it, and if you're fully insured, you don't really have a choice whether that's something that you're going to cover or not. So there is one major carrier, several major carriers that are covering treatments related to COVID-19. So hospitalizations, medications, doctor's visits, things like that, if somebody's diagnosed and has to seek treatment. Now, if you're self-insured, then you can affirmatively opt out of that, or you don't have to do that. But if you're self-insured, you do have to cover the testing requirements. So it's important that you understand what the carrier's doing as far as eligibility, like I talked about before, but also what are they covering, and tell your employees about that, because they're going to hear things and you want them to know what your plan covers so that there's no confusion and that somebody doesn't think that their plan is just paying for everything. It's so important to communicate right now.
So PPP, it's either the Paycheck or the Payroll Protection Program. That's one of the provisions of this recent legislation. And there's some confusion that we've heard from multiple employers and multiple sources around self-funded versus fully funded claims costs. So there's that question, and also, does it include other benefits besides medical?
So what we know so far about this PPP or payroll protection program is that it does allow an employer who receives one of these SBA loans, Small Business Association loans, that part of the loan can be forgiven. So it acts more like a grant in that case. They don't have to pay the loan back if they use it for very specific circumstances. So they have to have used most of the loan on payroll costs, and payroll costs can include or will include wages, commissions, tips, things like that. It also includes health plan or health premiums, health insurance premiums, and employee benefits costs. So in the rules or in the legislation, it doesn't point back to a specific piece of regulatory law or legislative law. So we can't really know for sure, but a lot of people are relying on ERISA's definition of a group health plan. And so that would include, if you're going to use that would include the things that are subject to COBRA. So medical, dental, vision, things like that. So things that provide medical care. We don't know for sure if that's true, but that may be something to rely upon. Also, the self-insured plans typically have the claims cost. And what a lot of people are saying is that it's probably a good idea to use the actuarial method for self-insured plans, so the COBRA rate, in other words. So an actuary generally would, or your TPA uses an actuary to determine the COBRA rates, and that would be the piece that could be forgivable. But hopefully we'll see some more guidance on that. But in this case, we don't know exactly what is included in that definition. So I would say that if you are going to try to get your loans forgiven, if you've received money from the SBA or through your bank through this SBA loan, then keep documentation of these expenditures, because you're going to have to show them to be able to get the loans forgiven. So,
right. More to come there, and we just got a couple left because we're running short on time. Are employers with under 50 employees exempt from having to provide this pay leave? There's some points about exemptions for smaller employers here. What does that look like?
So great question. If you're under 50, this does not automatically exempt you from having to provide paid leave. You have to demonstrate, you have to be able to show why this would harm your business financially. It's a hardship waiver. There's no form, there's no application. Don't send the DOL anything. They've explicitly said that on their website. Don't send us anything. What they have said is that you need to keep documentation as to why this would essentially kick you out of business, having to provide this leave. But keep in mind that there are payroll tax credits that you essentially hang on to the payroll tax instead of paying the IRS. You hang on to it in order to provide this paid leave. So it is a 100% payback of having to provide any paid leave for somebody that actually qualifies for it in the first place. So just keep this in mind. This is not going to apply to your entire workforce, most likely. It may apply to a few people. So that is why the 50 employee marker is there, because they understand that, if you have 5 employees, then that could be a very big financial detriment to the business. But so if you're going to rely upon this, keep documentation, and you'll have to show why you weren't able to provide the leave.
Great. So the last one is super common and important. We talked a little bit about communication is a vital part of what employers need to do anyway with their benefits plans. Do they have to update the SPD with these changes? Do we have to send out a summary of material modifications? What are the best practices? What's required? What does that look like here?
Normally, yes. Anytime there's a material modification to the plan, then you would have to distribute a summary of material modifications, which just basically telling the employee these changes were made, here they are. And then you would amend the plan document whenever, if you have a wrap document, the carrier certificates of coverage would come in and they would be updated with this information, and you would have that amendment. Now, right now, there are so many changes that are kind of flying at us, and we don't know if there are going to be further coverage mandates of some kind, maybe not, but really not sure. And eligibility too, that's kind of a fluid situation right now. So it may be better to hold off on sending out, 4, 5, 6 SMMs, and just instead communicate the changes to employees in writing, memos. Seen a lot of employers using memos, emails, of course, trying to just communicate to employees, these are the changes, this is what's covered, you're on furlough, but your benefits stay intact until the end of May, etc. And then maybe in June, July, even August, you amend your plan document, because at that point you know your changes, you know what's in place, and then or an SMM. So just kind of hold off on that, maybe, is what I would say.
Okay, more to come. I think that's it here.
Yeah, lastly, just some tips here, kind of overarching themes. Communicate, like I said, at least 20 times during this presentation. Communicate expectations about how you're going to charge while people are out, any changes that are relevant to the employees, what is covered, what is not. And then you want to document and keep records of any exemptions that you're going to try to rely upon. If you're receiving PPP, you're going to have to keep documentation to get your loans forgiven. Make sure you're working with the CPA and Employment Law Council on the little tricky issues here and there. It's totally worth using experts in this situation, because what can happen is things will come back and bite you in 6 months, 12 months from now, and you didn't really foresee it. So it's completely worth it to use experts in this time. Get your kind of tribe around you and utilize them, and do whatever you can to stay in business, of course. And then whatever the carriers are doing, get it in writing. They're going to be sending out things. Your broker's going to have that info. Hopefully they're sharing that with you. Keep it in writing, and don't forget about the ancillary carriers, meaning you have United Healthcare or Aetna or Humana for medical. Don't forget about, Sun Life, Reliance Standard, MetLife, any of the other carriers that don't write medical, but they write all the other types of lines of coverage. What are they doing? So get that in writing and keep it in sort of a folder, so you know what to rely upon and what to tell your employees.
Great. Well, I think that's it. I think we'll be signing off from the beach. That's a lot
Yes.
of information to cover. Thank you, everybody, so much for watching. Hopefully that info is helpful. Again, we're getting the same questions over and over again, so I'm confident that that's going to apply to some of your groups, or if there's some actual employers watching this.
And thank you, Tyler, for being on this presentation. I'm very excited to have his help. So thanks a lot. If you guys have any questions, please feel free to reach out to me, and make sure that you check out our exhibitor site to learn more about what we do and how we help brokers and employers to avoid hundreds of thousands of dollars in penalties and lawsuit exposure.
Yep. Absolutely.
Thanks so much.
Thanks, everybody.